Imagine you farmed the same land your whole life. You know every acre of it, every low spot that floods in spring, every ridge that dries out first in August, every fence line your grandfather set with his own hands. Then one morning, a truck pulls up the driveway. A man in a clean shirt steps out and tells you there's oil under your field. A lot of it. And before you can say a word, before you can even think about what that means, he slides a piece of paper across the hood of your truck and tells you that the oil isn't yours, that it never was. And according to the law, he's right. In America, the ground you stand on and what lies beneath it are two different things. They can be owned by two different people. They often are. And the gap between those two things has swallowed family farms whole. While oil companies walked away with fortunes from land they never once set foot on to farm, these are 5 families who found out the hard way what was buried beneath their fields and what it cost them to fight for it. In 1934, a railroad company sold a piece of land in Arkansas. The deed was standard, the kind written 1,000 times in 1,000 counties across the American South, except for one line buried near the bottom. The railroad reserved for itself all the minerals in or under the land. Nobody paid much attention to that line. The land was farmland. It had always been farmland. Minerals were something other people worried about. Coal miners and prospectors, not cotton farmers in Arkansas. Decades passed. The land changed hands several times. Each new owner farmed it. Each one assumed what most people assume, that when you own land, you own all of it. Then the oil company arrived. Kenny and Shelia Staggs had farmed that ground for years when Heartland Exploration showed up, with a lease already signed, not with them, but with Union Pacific Railroad, the successor to the company, that had written that one quiet line into a deed 80 years earlier. The Staggs went to court. They argued those mineral rights had passed through the chain of title to them, that the railroad's reservation had expired, that the land, all of it, was theirs. The circuit court disagreed. The Arkansas Supreme Court upheld it. The oil and gas beneath the Staggs farm belonged to a railroad company that had never once turned a furrow on that ground. A Texas farmer named Jones had a problem. Getty Oil had the mineral rights to his land. That was settled. He couldn't change it. But what Getty Oil was doing on his surface was making it impossible to farm. Their pump jacks were too tall. Jones ran an automated center pivot irrigation system, the kind that sweeps in a great slow arc across the field, watering the crop as it turns. Every time the irrigation arm came around, it hit the pump jacks. Getty Oil told him that was his problem. They had the dominant estate. They had the right to use the surface, to access what was underneath it. Jones disagreed. He took them to court. The Supreme Court of Texas sided with the farmer. The ruling was clear. Even when a mineral estate is dominant, the company cannot interfere with the surface owner's use. If a reasonable alternative exists, Getty Oil was ordered to bury their pump units in cellars below the surface of the field, deep enough for the irrigation arm to clear them. Jones kept farming. Getty kept pumping. And the law in Texas changed because one farmer refused to accept that owning the surface of a field meant nothing at all. The Ledgerwood family had farmed cattle in Garvin County, Oklahoma, for as long as anyone could remember. They owned the surface. A company called South Creek Energy owned the minerals beneath it. When South Creek announced plans to redrill a well on the Ledgerwood property, the family went to the Oklahoma Corporation Commission and asked them to stop it. They weren't asking for the oil. They weren't asking for royalties. They were asking for their water. Old oil wells, improperly plugged, leaking, had already contaminated groundwater in parts of Garvin County. The Ledgerwoods were afraid of what a new well would do to the water their cattle drank, to the land they'd worked, to the soil they'd built their livelihood on. The Corporation Commission didn't stop the drill. In 2014, South Creek redrilled the well on Ledgerwood land. The company produced about $4 million worth of oil and gas from the area. The Ledgerwoods received nothing, not a royalty, not a damage payment, not an apology, because in a split estate, the mineral owner is dominant, and the family that worked the surface had no legal claim to what came out of it. When natural gas companies moved into Pennsylvania's Marcellus Shale region in the 2000s, they moved fast. They knocked on every farmhouse door in the gas-rich counties and made offers to lease the mineral rights. Dairy farmer Charlie Clark signed a lease. The company drilled. Charlie got his royalty check every month. He bought a new hay baler with the first one. "I thank God every day that it happened here," he said. His neighbor Jim Barrett also signed a lease. Same county, same gas formation, same company. Jim Barrett got nothing. Not because the gas wasn't there. It was there, but the geology of the Marcellus Shale is uneven, unpredictable. The gas pooled under Charlie's land. It didn't pool the same way under Jim's. And somewhere further down the road, a third farmer. He watched both his neighbors sign leases. He waited for the knock on his door. It never came. Because when he finally had an attorney search the title to his property, really search it, they found something in a deed from 1952. A previous owner had sold the surface rights and retained the mineral rights. Those mineral rights had passed to heirs, scattered across 3 states. The gas company had already found them, already signed with them, and was already drilling on a farm the surface owner had worked his entire life, collecting nothing. In 1953, a man named C.C. Fay sold a piece of Ohio farmland. When he wrote the deed, he reserved for himself all veins, beds, and deposits of minerals and other minerals in the property. It was 1953. Oil was already being pumped across Ohio. Fay knew what he was doing. Or did he? In 1973, the land transferred to Faith Ranch and Farms, a nonprofit organization. Fay died in 1983. His mineral rights reservation passed to his heirs through a bank trust, and for decades, nothing happened. Then, in 2021, the heirs came looking. They went to the Harrison County Common Pleas Court and asked for the oil and gas rights back. Rights they said Fay had reserved in that 1953 deed. Faith Ranch pushed back hard. They argued the word minerals in the deed didn't include oil and gas, that veins referred to solid minerals, coal iron, not liquid hydrocarbons. The trial court agreed with Faith Ranch. The 7th District Court of Appeals disagreed. They found the language ambiguous, that it could include oil and gas. The case went to the Ohio Supreme Court. In 2026, the Supreme Court sided with the heirs. The oil and gas rights, sitting untouched beneath that Ohio farm for over 70 years, belonged to the family of the man who had written one careful sentence into a deed in 1953. One sentence, written before most of the people involved in the case were born, and it's still held. In America, the mineral estate is dominant. That means what's underground has more legal weight than what's above it, more weight than the crops you planted, more weight than the cattle you raised, more weight than the family name on the mailbox. Most farmers never know this until the truck pulls up the driveway, until the man in the clean shirt slides the paper across the hood. The ones who came out ahead were the ones who read their deeds before that moment, who knew what line to look for, who understood that the ground they stood on and the ground beneath their feet were not always the same thing in the eyes of the law. One sentence in a deed written in 1953. One farmer in Texas who refused to let the irrigation arm be stopped. One family in Arkansas who took it all the way to the Supreme Court. They didn't all win, but they all did the same thing. They looked down, and they asked, what exactly is mine? New stories every week on Deep Furrow.